Welcome to the fourth lecture of our course. This one is dedicated to the analysis of the current configuration of the European Union. In particular, in this lesson, we will deal with the strengths and the weaknesses of the European Union. On the one hand, the analysis of the current strengths of the European Union concerns three aspects: its institutional framework, the protection of fundamental rights, and the promotion of common aims and values that cannot be undermined. On the other hand, as far as the European Union's weaknesses are concerned, they can basically be summarized in three factors: the ineffectiveness of procedures to enforce the violation of common values, the complexity of certain legislative procedures, and the limitation of the competence conferred. Starting from the strengths, certainly one of them is the provision of an institutional system that allows the Union to act independently of the Member States. In fact, as we already seen in the previous lesson, the European Union institutions have specific tasks and allow the autonomous achievement of the goals set out in the founding treaties of the European Union. In this scenario, we could say that the European Parliament and the Council of the Union act as the legislators of this special order. The European Commission represents a kind of executive body that supervises the work of both the EU Parliament, the Council of the Union, and the Member States. The European Council coordinates the general work of all institutions and determines the overall direction of individual policies. And finally, there is a supreme judge, namely the European Court of Justice, who ensures that European law is respected by both institutions of the European Union and the Member States. In these terms, we can argue that the European Union is an order sui generis, that is to say, that the European Union is a unique model endowed with completeness and functional autonomy. In the 1957 founding treaties, there was no provision for the protection of fundamental rights with regard to the Union's activities. This situation created an obvious contradiction, since the European Union could have exercised competences transferred to it by the Member States without encountering any limitation with regard to the respect for fundamental rights, whereas the same competences, if exercised by the Member States, would have encountered the limitation of respect for the fundamental rights guaranteed by each national constitution. In other words, the transfer of competences from the states to the Union would have created a sort of free zone with respect to the need to ensure uniform protection of fundamental rights. It was precisely this lack of uniformity that was noted by the national constitutional courts, in particular the Italian and the German ones, that suggested the promotion of a process for the protection of fundamental rights. As a result of this process, we are now able to identify the sources and tools of protection of fundamental rights within the European Union's legal system. We can also clarify the relationship with the fundamental rights guaranteed outside that system, either in the national legal systems of the Member States or through international human rights instruments. The complexities of the subject of fundamental rights in the Union's legal system are now provided for in Article 6 of the Treaty on European Union, which indicates three categories of sources of fundamental rights. The first one, established by paragraph 1, is the Charter of Fundamental Rights of the European Union, the Nice Charter. The second one, referred to in paragraph 2, is the European Convention on Human Rights. Notably, the provision establishes a legal basis for the access of the European Union to the European Convention of Human Rights. The third one, to which paragraph 3 is dedicated, is the general principles of law. In turn, these principles are reconstructed on the basis of two elements: the common constitutional traditions of the member states and the rights guaranteed by the European Convention on Human Rights. The European Union's aims are laid out in Article 3 of the Treaty on European Union. The European Union has two different kinds of aims, the ones inside and the others outside its borders. Starting from those within its borders, the European Union aims to promote peace, its values, and the well-being of its citizens. The European Union aims to offer freedom, security, and justice within internal borders, while also taking appropriate measures at its external borders to regulate asylum and immigration and prevent and fight crimes. The European Union aims also to establish an internal market, achieve sustainable development based on balanced economic growth and price stability, and a highly competitive market economy with full employment and social progress. The European Union aims to protect and improve the quality of the environment. In addition, the European Union aims to promote scientific and technological progress, combat social exclusion and discrimination, promote social justice and protection, equality between women and men, and protection of the rights of the child. Finally, the European Union aims to enhance economic, social, and territorial cohesion and solidarity among EU countries, respect its rich cultural and linguistic diversity, and establish an economic and monetary union whose currency is the euro. The aims of the European Union outside its borders, and so within the wider world, are the promotion of its values and interests, the contribution to peace and security and the sustainable development of the earth, its contribution to solidarity and mutual respect among peoples, free and fair trade, eradication of poverty, and the protection of human rights. And finally, the strict observance of international law. The European Union is based on the following values: the human dignity, the freedom, and the democracy. The human dignity is inviolable. It must be respected, protected, and constitutes the real basis of fundamental rights. Freedom of movement gives citizens the right to move and reside freely within the Union. Individual freedoms such as respect for private life, freedom of thought, religion, assembly, expression, and information are protected by the European Charter of Fundamental Rights. The functioning of the European Union is founded on representative democracy. A European citizen automatically enjoys political rights. Every adult EU citizen has the right to stand as a candidate and to vote in elections to the European Parliament. EU citizens have the right to stand as a candidate and to vote in their country of residence or in their country of origin. When we talk about European values, we should consider also the equality, the rule of law, and human rights. Equality is about equal rights for all citizens before the law. The principle of equality between women and men underpins all European policies and is the basis for European integration. It applies in all areas. the principle of equal pay for equal work became part of the Treaty of Rome in 1957. The European Union is also based on the rule of law. Everything the European Union does is founded on treaties deliberately and democratically agreed by its EU countries. Law and justice are upheld by an independent judiciary. The European countries gave final jurisdiction to the European Court of Justice. That is to say that its judgments have to be respected by all. Human rights are protected by the European Charter of Fundamental Rights. This charter covers the right to be free from discrimination on the basis of sex, racial or ethnic origin, religion or belief, disability, age or sexual orientation, the right to the protection of your personal data, and the right to get access to justice. Turning to the weaknesses of the European Union, one of them is certainly the ineffectiveness of procedures to assert the violation of common values. Indeed, as Article 7 of the Treaty on European Union stands today, it establishes three different procedures deployable to safeguard the values of Article 2 of the Treaty on European Union. A procedure to declare the existence of a clear risk of a serious breach of the values referred to in Article 2, and the adoption of recommendations how to remedy the situation addressed to the Member State in breach. 2. A procedure to state the existence of a serious and persistent breach of values. And 3. A sanctioning mechanism following the statement of a serious and persistent breach. Article 7 of the Treaty on European Union does not exclude the possibility of starting the procedure laid down in Article 7, paragraph 2 directly. All its three paragraphs are thus not part of one procedure with three steps. The most popular presentation of Article 7 today is to refer to it as a nuclear option. This idea is based on, let's say, the assumption that invoking the provision is extremely difficult and the results of its application are too devastating to make this practicable. This seems quite absurd because, despite the fact that among the admission criteria that must be fulfilled to become a member state, there is also the observance of the values of the European Union, the so-called Copenhagen criteria. But once the state is part of the European Union, there are no procedures to enforce these values. And this is a paradox, for sure. Indeed, by means of its persistent failure to trigger Article 7 of the Treaty on European Union early enough to prevent acute rule of law backsliding, the European Union emerged absolutely incapable of enforcing what it officially believes in and what is obliged by law to promote around the world. A second current weakness of the European Union is the complexity of certain legislative procedures. The complexity of certain legislative procedures, especially those where unanimity is required in the Council of the European Union, is a weak point of the Union because it often happens that an agreement cannot be reached and thus some acts risk not to be adopted. The third current weakness of the European Union is the limitation of the competences conferred. With regard to this limitation, on the one hand, we can say that under the principle of conferral, the European Union shall act only within the limits of the competences conferred upon it by the Member States in the treaties to reach the objectives set out therein. Indeed, all the competences not conferred upon the Union in the treaties remain with the Member States. For this reason, it appears that this principle weakens the European Union because it allows the Union to act only within the bounds of competences recognized in the treaties. On the other hand, the principle of conferral guarantees the independence and sovereignty of the member states, thus undermining European integration. Thank you again for your kind attention.